Good afternoon. Merry Christmas. The poll looks pretty strong. It looks like we have 76 votes yes, 27 votes also yes, as long as you could sit on my face. Hit me up, we'll work something out. And only 46 votes no. So it's pretty overwhelmingly yes. So we're going to keep the face in it. I have made it smaller and I put it in the lower right corner. I'm going to try to be cognizant of documents and things like that. Try to keep the coverage of the text down to a minimum. Someone sent me a link to this. I don't know why. It was either Kelly Fitzpatrick or Patrick Fitzkelly. I don't remember who sent it to me, but someone sent it to me. And I absolutely hate sovereign citizenry, sovereign citizen stuff, and all that good stuff. So, yeah. Anyway, send it to me, and the first thing I normally do is I read the description, and there is a link. This is apparently a mirror. So this is the original artist, whatever. And yeah, I have poked around a bit. I have checked out People v. Horton. That appears to be the case that he has up here. I've read it. I've Googled no license necessary to drive on public highways. I come up with this place that is a gish gallop of sovereign citizenry bullshit. It has the obligatory Chicago motor coach versus Chicago. Boy, I'm assuming it has all the standard misquotes as well. And held that carriages were properly classified as household effects, and we see no reason that automobiles should not be similarly disposed of. Oh, Jesus. And then I also went to Google Scholar, case law just in general. I did not limit it to any court system. And I checked for this quote, which he had quoted without giving attribution to the quote, and no case popped up. So I think he's actually quoting this my-legal.tripod.com. I think this is what he's quoting. He just never actually attributes it to that. He also doesn't link to it, even though he's apparently stealing from it. So anyway, that's cool. That's cool. We're going to jump into sovereign citizenry, and this is going to be a thing. I do hate sovereign citizens, and I'm going to tell you the reason why I hate sovereign citizens is because they fail to use the most easily used test to determine whether or not their belief is sound. And that's the reality test. Reality exists. And you could just look out there and you could see that people are getting arrested and convicted of driving without a license. And you have to ask yourself why. And maybe some people get away with it, But again, you should ask yourself why. Why do some people not get away with it? Is it because they just don't know the law? Is it because the courts don't know the law? Is it because the police don't know the law? Why? And why is it that every time that someone says something like, the Supreme Court rules no license necessary to drive on a public highway, they don't actually show a Supreme Court case, number one. And number two, it never says no license is necessary to drive on public highways. The reality test is a pretty basic test. It's a really basic test. And you should apply it more often. You should apply it more often. Like, for example, again, we're going back to Mark Stout. Like, if it is a presumption that all city halls are limited public forums, why did the court in Sheets versus City of Punta Gorda say that the parties have agreed that this is what it is? Instead of just saying, well, it is a city hall and therefore it is necessarily a limited public forum. And if that was the end of the test, limited public forum, they could trespass you for it. If that was the end of the test, why did the court then continue to go through the analysis? Why did the court need all those other facts about the city hall and what happens at the city hall? Why did the court need all that stuff? Again, reality is a pretty basic bar. It's a low bar, it's a pretty basic bar. If your expectations don't match reality, change your expectations to match reality. Don't try to change reality to match your expectations. So let's just start off with People versus Horton, because that's what he's going to jump into. I'm assuming he has it up on his screen. He has a highlighted portion. People versus Horton. I've read it. It's a 1971 case. It came out 3 years after Terry v. Ohio. I think Terry v. Ohio was published in '68. So the whole reasonable suspicion thing had just kind of come out. The officer in this case stopped a young man while driving a car because he had a couple Utes with him, and that's it. That's all he suspected. Was it? There's young people in this car. Turns out that the car, I think, was stolen. There were no keys in the ignition. He found some marijuana joints in the car. But when he had asked for permission to search, he said, "Hey, can I search your car?" After he had stopped their vehicle, after he had seized them for Fourth Amendment purposes, he asked if he could search the vehicle, and they said yes. He searches the vehicle, finds the marijuana, and all of a sudden these kids are getting this young man and the two kids are getting arrested and charged with possession of marijuana. And so they try to suppress the evidence. And they say, well, the seizure was in violation of their Fourth Amendment rights. And so everything subsequent to that seizure is a violation of my Fourth Amendment rights. And so the court's doing an analysis, a Fourth Amendment analysis. Did the cop have reasonable suspicion or probable cause? They kind of waffled in it. It's not a really clear opinion. They talk about reasonable suspicion in this paragraph, but then they go on to say that the officer didn't have probable cause. Anyway, but the point is that the court's looking to see if the officer had the requisite level of reasonable suspicion, probable cause in order to stop the vehicle. If he didn't, then everything else would be suppressed. And then the court said that the stop, having been illegal, the search through the consent of the vehicle owner does not breathe legality into the resultant fine by the officers. So that's what it's about. This is a Fourth Amendment case. This is a suppression hearing or a suppression of evidence case. It has nothing to do with license. There's no discussion of a license in the actual case. So we'll see what he has to say about it. Is there anything else that I had noted here? No, we have all the links to give him money. I had noticed these. I had searched a few of them. They're all pretty old. The ones that I looked at don't say anything about what he wants it to say. I mean, look, 78, 69, 71, 66. What are they talking about and why? Is there anything more recent? The answer to that question is yes, there is. But we'll go ahead and listen to his argument. We'll see what he has to say.
I titled this video, Supreme Court Rules No License Necessary to Drive on Public Highways. I am not a lawyer. I am not giving legal advice, but
Isn't it funny how immediately he goes into, I'm not a lawyer, I'm not giving legal advice. Why is he doing that? Well, he's doing that because it's pretty apparent that the state has the power and I'm going to say right, but they have the power, they have the ability, they have the, it is constitutional for them to regulate the practice of law and to require licensing for the practice of law and to punish people for practicing law in violation of their licensing requirements. This sovereign citizen guy right here is not licensed to practice law. And so he is disavowing that he's practicing law or that he's an attorney because he knows that the state can license certain things. And the state has the power to regulate certain things, like the practice of law and like driving on public highways. So he understands that he can get in trouble for it, and so he's distancing himself from it. Now, you might ask yourself, why does the state regulate the practice of law and require a license for it? Well, that's because they want to make sure that you get a certain minimum amount of objectively good counsel. And what this guy gives you is pure bullshit.
I am going to read from an appellate court. I'm going to read from Supreme Court cases that the Supreme
Courts don't testify. They give opinions. Testimony is what a witness would do in the witness box. Percipient witness would testify as to what they saw, heard, tasted, touched, smelled. A expert witness would give the underlying facts, things that other people had saw, tasted, touched, smelled, heard, and then they would extrapolate from those based on their expertise, the meaning behind it, what those mean, like based on the stippling pattern, based on the burns around the entry wounds, around the entryway, based on the depth of the wound, based on the fragments of lead found in the wound. I have determined that the bullet was a .22 caliber bullet. That's what an expert does. So judges don't testify. They render opinions, or they make findings of, if it's a bench trial, they'll make findings of fact. They'll put a judgment out, but it's not, but they don't testify. So just the fact that he doesn't understand that distinction should cast doubt on his ability to understand what he is referencing. And the fact that he's leading off with a Fourth Amendment case, big and bold, a California Fourth Amendment case, which has absolutely nothing to do with anything outside of California, zero to do with anything outside of California. And it's an old case, 1971. It is a 1971 case. So these are the things that should tell you that he doesn't know what the fuck he's doing or why.
Court testifies, the lower court testifies that you don't need a license to drive on public highways in America.
So he's going to find us something that says no license is necessary to drive on public highways in America, right? Or he's going to dance around single sentences like they always do, trying to make a case for it. See, what he's really doing is he's making a case for it. A court has not found this to be the case. He is trying to make a case for it based on dicta and misunderstood language out of other court cases.
Again, I'm not giving advice. Do what you want, but just educate yourself. Remember, Samuel Adams said, "No people will tamely surrender their liberties, nor can any be easily subdued when knowledge is diffused and virtue is preserved."
He's assuming that you have a right to drive, and you don't. You have a privilege to drive. The state can and does license it. The state has to set metrics. They can't arbitrarily or capriciously deny you a license. But they can set various metrics in place, like you have to pass a test, written test, a driving test. You have to have a certain level of vision, a certain level of hearing, whatever. They can set the kind of basics for you to get a license. Once you have a license, they can't revoke that license without due process of law, notice and an opportunity to be heard. But that doesn't mean you have that doesn't mean it's a fundamental right. The fundamental right is something that the government can't take away from you unless it passes a strict scrutiny test, a compelling interest kind of test. And that's not what has to happen. It's a rational basis test for taking away your driving privileges. It's the lowest bar instead of the highest bar to take away your driving privileges. Because the 14th Amendment does require procedural due process before depriving someone of their life, liberty, or property. And you have I think it's a property interest in a driver's license. And so they can't take that away from you without procedural due process, notice and opportunity to be heard. But it's like the most basic kind of thing ever.
On the contrary, when people are universally ignorant and debauched in their manners, they will sink under their own weight without the aid of foreign invaders.
And exactly. So when these people go out here listening to ignorance, listening to people say that you have that no license is necessary to drive on public highways, they're going to infer from that it's legal to drive without a license on public highways. Because you're not actually saying it. You're just saying no license is necessary to drive on a public highway. You could absolutely drive illegally on a public highway without a license. I mean, you don't need it's not like having to have gas in your tank or something like that. It's not a necessary prerequisite, but it is a legal prerequisite. So, your ignorance is going to affect other people who are going to then act ignorantly, who are then going to get arrested or ticketed or towed or whatever, and they're going to face legal consequences for their ignorance which you have helped pound into them. that you've reinforced in them. You're reinforcing the ignorance of people.
When knowledge is diffused, it's very, very difficult to come against somebody who has that knowledge.
And when disinformation is diffused, it's also very, very difficult to disabuse people of that disinformation. People like to cling to it. They have a belief, a hope, a desire that they can drive without a license, and so any information or disinformation they get that supports that belief, they're going to cling to. And unfortunately, reality is a cruel mistress.
Because knowledge is power.
Not necessarily, and it really depends on how you're going to define these things. That's one of those catchy little phrases that doesn't really mean anything, but could mean something. You know, knowledge isn't necessarily power. You know, it's some knowledge can be used to give you power over something or someone, but knowledge is not in and of itself power. That there's a reason. There is a reason why they have two different words, one for knowledge, one for power. It's because knowledge is not necessarily power.
And so I'm going to start from the ending and work our way back.
So this, I'm surprised. I am surprised if this is his strong case, he's already failed. Because again, this is a Fourth Amendment case, not a right to drive case. You've already failed. If this is the end, if this is like the best you got, a 1971 Fourth Amendment case out of California, if this is the best you got, dude, you have failed.
And the thing I want to key in on in this case, People versus Horton, is this little phrase right here, this little sentence. The right of the citizen, and we can talk about, the word citizen versus people, because you're not a denizen of the city, you're an individual. The right of a citizen to travel on
Hold on.
People, because you're not a denizen of the city, you're an individual. The right of a citizen.
Oh my God, word magic. He's a word magic sovereign citizen. Holy Jesus, word magic. Officer, I'm not standing under that. The citizen is like a subject of a state or a nation, or a national. Like I'm an American citizen. I'm a citizen of the state of California. I mean, I guess technically you could be a citizen of a city too. But why, like, if you can use citizen to be like a citizen of California in a California Court of Appeals decision, why would the California Court of Appeals be talking about the citizen of a city?
Citizen to travel on a public street with freedom from police interference unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right, not a privilege.
So see this comma here and this comma here. This little bit of sentence needs to be read as a whole. The right of the citizen to drive on a public street without freedom, with freedom from police interference. That is a unit. That is a unit. It's the right of the citizen, and then to drive on a public street with freedom from police interference. It's not the right of the citizen to drive on a public street and then throw the rest of the way. It's to drive on a public street with freedom from police interference. You have a right to do that. With or without a driver's license, you have a right to do that. However, if the officer has reasonable suspicion or probable cause, he can pull you over and he can demand your driver's license. And if you don't have it, you are subject to the penalties for driving without a license, which may include, but are not limited to, having your vehicle towed, getting a ticket, getting arrested. There are going to be penalties, but he can't. But just because you don't have a license doesn't mean the officer can pull you over without reasonable suspicion or probable cause, because that is a Fourth Amendment test. The right of the people to be secure, their papers, houses, and effects. Fourth Amendment. Let's look it up. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. So it's like saying the right. Where are we at? The right of the citizen to grow plants in his home with freedom from police interference, unless the police have probable cause and a warrant, is a fundamental constitutional right which must be protected by the courts. That doesn't mean that you can grow marijuana in your house. You have a right to be free from unreasonable searches and seizures, regardless of whether you're committing a crime or not. The search or seizure has to be reasonable, which means that at a bare minimum, reasonable articulable suspicion, generally speaking, probable cause. That's all it's saying. It's not saying that you have some right to drive. It's saying that you have a right to be free from police interference unless they have reasonable suspicion at a minimum. And it doesn't also say that the right to drive is a fundamental constitutional right. It's the right to be free from the police interference is a fundamental constitutional right.
Must be protected by the courts. It is a fundamental, elementary.
It doesn't say elementary.
Constitutional right. Because I keep hearing people saying what drove me toward this in the last couple of days is, for some reason, this video was recommended to me in my YouTube list, and I listened to it, and I stumbled upon this section in this video. It's called "Why Restrict Good Gun Owners Resident?" Asked President Obama at Town Hall. This was from June 2nd, 2016. Listen to what Obama says. The broader context of this is, Hillary and I are not trying to take away your rights, but there's got to be common sense gun regulation. You're for common sense gun regulation, aren't you? And then he tries to correlate this with, well, everybody needs a license to drive a car. Why wouldn't you need a license to buy a gun? Here's what.
Well, that's a stupid thing. I mean, so he's taking it backwards. Obama is saying you need a license to drive a car. So why not have a license to drive a gun? Well, the reason is because you have the Second Amendment. The Second Amendment says you have the right to keep and bear arms. You don't have an amendment, a constitutional amendment, saying you have a right to drive a car. So Obama's going from something that is a rational basis test, giving or taking away licenses to drive a car, to something that would be strict scrutiny. What this cat apparently seems to be doing, what do you call him? What Mr. Young is attempting to be doing is saying, well, if you have strict scrutiny for the gun ownership, then it should also be strict scrutiny for driving a car, ignoring the fact that the gun ownership is in the Constitution and driving a car is not. So he's picking up that Obama's making a bad argument, but he's then misconstruing it backwards. He's taking it the wrong way. He doesn't understand that the reason why Obama's argument is bad is because you don't have a constitutional right to drive a car. Mr. Young is going from the operative angle that you have a constitutional right to drive a car, therefore you should have the same protections as for gun ownership.
Obama said,
if you buy a car, if you want to get a license, first of all, you got to get a license. You have to take a test. People have to know that you know how to drive.
you got to get a license? Well, not according to the Constitution, not according to natural law, which is the most important, or the.
No one enforces natural law. Anytime anybody is invoking natural law, they're just saying that this is my opinion. Natural law is just my opinion on the way things should be, because it's my opinion, and I want you to give my opinion more weight than it actually has, and so I'm going to call it natural law.
Supreme law of the land, which is the Constitution, or the Supreme Court, or the lower courts. There are many.
And if the Constitution is the supreme law of the land, why even mention natural law? If, as you are saying, that it's in the Constitution, why would you have to mention natural law?
Many rulings, and we're just going to go over this one right here, People versus Horton. And it's an interesting story, so stay with me, because basically I'm going to be reading from this Court of Appeals of California 5th Appellate District, but it's also been upheld by the Supreme Court. The Supreme Court.
Really? Where? Why aren't you showing us the Supreme Court decision, sir?
Appellant was convicted of possession of marijuana in violation of Health and Safety Code Section 11530. The marijuana was found in appellant's automobile after he consented to the search of the vehicle. Now, this is going to be very, very important later on in this case. Appellant presents two main points for reversal: that the officer who stopped the vehicle did not have probable cause to do so or to detain appellant; that a search made pursuant to consent immediately followed an illegal detention is invalid. This is going to become very important here in a second.
Yeah, and none of that had fuck all to do with a license to drive.
So there are a couple kernels of truth to add to our knowledge banks on this court decision. The facts are undisputed.
Kernels of truth. I like kernels of truth.
Appellant, a 20-year-old youth, was stopped by Officer Winfrey while driving an automobile on McHenry Avenue in Modesto at about 1:15 in the morning. There were two...
I tell you what, the first time I read Officer Winfrey, I read it as Oprah Winfrey, and I had to do a double take. I'm like, she's been a cop? What?
Passengers in the car, appellant's 15-year-old brother and his 10-year-old cousin. As Officer Winfrey approached the automobile, he noticed that there was no key in the ignition. The officer mentioned this fact to appellant and was told that appellant had lost the keys about 2 weeks earlier and that he had to hotwire the vehicle to start it. Winfrey asked appellant's permission to search the automobile, and permission was granted. He found 2 burnt cigarettes in the glove compartment. Officer Winfrey then asked to see vehicle registration slip, and when he discovered that the car was registered to Lillian Lacus in Rosemead, California, placed appellant under arrest.
Well, thank God we know all this background, because this is going to be super important coming up to show that you don't need a license to drive on public highways.
Appellant was searched, and a rolled cigarette was found in his shirt pocket. All 3 cigarettes contained marijuana. So you would think, oh, busted. It's curtains for this guy. It's all over. Well, that's not how the court saw it.
No, it's not, because the search was without reasonable suspicion or probable cause.
It is, of course, true, as respondent maintains, that the provocation required to permit a police officer to temporarily detain a person for questioning is not the same as that required for a valid arrest or a lawful search. Nevertheless, and that gives a couple court cases right here. Nevertheless, the right of a police officer to stop a motorist or detain a pedestrian for questioning is not without constitutional restriction.
Right. It's the Fourth Amendment.
You hear that, cops? Your ability to even stop somebody during a traffic stop that you think is warranted is not without constitutional restriction. You're bound still by the Constitution. The applicable
reasonable suspicion.
Rules were succinctly summarized by Mr. Justice Tamara in Williams versus Superior Court, and gives the court case as follows. And here's a quote from that. So here's an appellate court citing a Supreme Court, a Superior Court case.
No, this is not. This is a California Court of Appeals case. It's not a Supreme Court or a Superior Court case. See Cal App 274, Cal App 2D. Cal App is referencing the California Court of Appeals. California, the Superior Court is the baseline, the bottom court. Then you appeal to the, generally speaking, you appeal to the California Court of Appeals. There's also an appellate division of the California Superior Court that you can appeal like misdemeanors and traffic tickets to. But generally speaking, you go from the Superior Court, you appeal to the Court of Appeals, and then from there it goes to the California Supreme Court. A California Supreme Court citation would be like 274 cal.2d. It wouldn't have the app there. So if it's just cal.2d, then that would be a California court or California Supreme Court. But all of these are just for California, so I don't even know what. And it's from 1971. Just to put this in perspective, that's half a decade ago. What happened since then? Bueller?
As follows, quote, thus, although circumstances short of probable cause to arrest may justify an officer's act in stopping and temporarily detaining a motorist or pedestrian for questioning, there must be some suspicious or unusual circumstance to justify even this limited invasion of a citizen's privacy. So it sounds...
Fourth Amendment. Yep.
like this appellate court is completely on the side of the individual and wants to hover over and maintain and secure and protect this individual's rights, unalienable rights. And then it gives...
The court wants to protect the individual's Fourth Amendment rights. Sure.
More court cases. Generally, the test is whether the circumstances are such as to indicate to a reasonable man in a like position that such a course is necessary to the proper discharge of the officer's duties, and that gives this People versus 1960 Cadillac, and it's got a couple other court cases right here. More specifically, the officer must be able to point to specific and articulated facts which, taken together with rational inferences from the facts, reasonably warrant that intrusion. It's got
Terry v. Ohio. Jesus fucking Christ. It's a Fourth Amendment reasonable suspicion test.
it even quotes Terry v. Ohio here, which is pretty interesting. A mere hunch
It is pretty interesting. I'm sure that Chili's just absolutely pooping himself there.
or subjective suspicion will not justify a temporary detention. And yet that's what you see in Terry v. Ohio. Oh, officer safety trumps individual rights is what Terry v. Ohio.
No, they're literally quoting Terry v. Ohio here, you dunce. The court found that it wasn't a mere hunch or subjective suspicion. They found that Officer McFadden was able to articulate facts sufficient to warrant a reasonable person to believe that there was crime afoot.
Ohio should actually be turned. And unusual activity alone, unless there is some...
Just the fact that he thinks that Terry v. Ohio says that officer safety trumps everything ignores the fact that Terry v. Ohio found as a matter of law, that Officer McFadden had reasonable, articulable suspicion. He had the reasonable suspicion supported by the articulable facts that would lead a reasonable person to determine that crime is afoot. A reasonable person to believe that crime is afoot, I guess.
Some suggestion that is related to criminality is insufficient. And then they say, applying these principles, these are principles to the incident case, we're
These are principles. What? What? They're principles? Oh my God.
compelled to conclude that Officer Winfrey did not have legal cause to stop appellant's automobile.
Legal cause to stop the automobile. Does that say that we're impelled to conclude that Horton had a fundamental constitutional right to drive on public highways without a license? Oh wait, no, it doesn't. It doesn't. It doesn't say that.
Appellant was driving within the legal speed limits, not erratically, and there were no visible operational defects in the vehicle. Furthermore, although the officer observed 2 young passengers in the vehicle, he saw no furtive or suspicious movements, and he had no information that the youths were being kidnapped, detained, or molested in any manner. In fact, the only reason given by Winfrey for stopping appellant was that appellant was driving a vehicle along the streets of Modesto at 1:15 in the morning with 2 young passengers, and that he did not look old enough to be their parent or guardian. That's all he had.
I apparently wasted my time reading the case. I thought we were going to deal with a bunch of cases. I apologize. I thought we were going to deal with a bunch of cases in this because he had several cases listed and.
According to his testimony. Clearly, even if we should assume that what the officer observed constituted unusual activity, and it is difficult to make such an assumption in this modern age, the activity alone did not suggest that it was related to criminality.
It did not suggest that crime was afoot.
And this brings us back to, they can't even ask you to be insecure in your person's houses, papers, and effects, or specifically in your person.
They can't ask you to be insecure in your person's house, papers, and effects, specifically in your person. Yeah, they can. They can ask you to search. They can ask you if they can search you. And if you give them, if you say yes, you can, then generally speaking, it's going to be a valid search. They could always ask you to waive your constitutional rights. They could always ask you. And if you do it, then that's on you. Now, in this case, because of the illegal seizure of the vehicle, the subsequent search was invalid. But had the initial seizure of the vehicle been supported by reasonable suspicion, then the subsequent search based on the agreement by the driver to allow the police to search the vehicle, it would be a valid search.
Ask you for your ID. Guys, privacy is a human right.
Where do you get, hold on, they can't ask you for your ID now?
They can't even ask you to be insecure in your person's houses, papers, and effects, or specifically in your person. Ask you for your ID. Guys, privacy is a human right.
Well, this case does not support that. This case does not say anything about you don't have to ID. There is a California statute in place that says if you're stopped if you're legally stopped driving a motor vehicle, the officer can demand your ID. California Vehicle Code. I mean, it's still a valid vehicle code. Hasn't been overturned. Supreme Court hasn't said, no, California, you can't do that, bro.
Right. Your privacy, your anonymity is a human right. It's an inalienable right. When an officer tells you, hey, I need you to consent to me intruding upon your right to privacy by giving
I need you to consent to it? Well, that would be silly. You could always say no to that.
me your ID without there being any suspicion or articulable suspicion that you committed a crime, he's violating his constitutional oath to protect.
No, he can always ask. There's no constitutional requirement saying that he can't ask you to do things when they aren't supported by reasonable suspicion or probable cause. Again, reasonable suspicion or probable cause only relate to searches and seizures. So if a cop asks you for your ID, well, are you free to walk away? If you're free to walk away, you can walk away. You don't have to give it to him. But if you do reach into your pocket and hand him your ID, he's not searching you. You've consented to giving him this information.
Protect you and to protect your privacy. Period.
Wait, where does it say that the cop has to protect your privacy? Where did the cop sign up saying, I'm going to protect your privacy?
A suspicion or articulable suspicion that you committed a crime, he's violating his constitutional oath to protect you and to protect your privacy. Period.
He made a constitutional oath to protect you and your privacy? The Fourth Amendment doesn't say I'm going to protect your privacy. It just says that you have a right to privacy. It doesn't say that the cops are going to protect your privacy. You're dumb.
According to the courts, according to the Constitution, according to natural law.
No. The court didn't say that. The Constitution didn't say that. Natural law is just your opinion. You're the only one saying it.
According to what we all know in our hearts to be true.
Well, that's it. Well, if we all know in our hearts to be true, I guess I don't have a heart because I don't know that to be true. Which I probably don't have a heart. I am an attorney.
The Attorney General argued that Officer Winfrey had reasonable cause to stop appellant's vehicle on suspicion that appellant was aiding and abetting his two young passengers to loiter in violation of the municipal ordinance of the city of Modesto. And then he says, however, driving along city streets even at 1:15 in the morning is not loitering, the court says. For all that Officer Winfrey knew, appellant could have been driving his two young passengers home from a theater or other authorized place of amusement. We are not insensitive to the numerous problems which face police officers on patrol in a mechanized nation, as we stated in this Superior Court case right here. And then they quote it, quote, the use, and it's got this code, of the automobile in criminal activity has vastly increased the possibility of unlawful conduct and the likelihood of escape by criminals from the scene of their crimes. Moreover, we are cognizant of the fact that the great majority of police officers assume the grave responsibility which our society has foisted upon them in a courageous and conscientious manner. Nonetheless, and that brings us to this quote right here. Nonetheless, the right, not the privilege, Obama, because people are constantly saying that driving a car or transporting your personal property from A to B on the public highways is a privilege granted to you by the government.
It is a privilege.
Not an inalienable right given to you at birth by God or whoever, or it's just inherently in you. They're constantly calling it a privilege. Again, not according to the Supreme Court, not according to lower courts, not according to the Constitution, and for goodness sake, not according to natural law. I mean, where do you...
For goodness sakes, not according to natural law. For goodness sakes. For goodness sakes. Driving privilege will be suspended. Hernandez versus Department of Motor Vehicle. 1981 California Supreme Court case. The right to drive a motor vehicle on the public highways is not such a fundamental right as to require strict scrutiny of any law, which appears to be classifying the driving privileges of a person otherwise similarly situated and to necessitate a compelling state interest before such a classification may be justified. You have a 14th Amendment due process right to notice an opportunity to be heard before you have your license taken from you. But you don't have a right to drive. What about Perky? This is also a California Supreme Court case from 1986, driving privileges. The significance of these fraudulently obtained licenses becomes evidence when one considers a multitude of cases in which the department denies, suspends, or terminates the driving privileges of persons who are dangerous drivers. It is a privilege. What about People v. Moran? P-E-O-P-L-E v. M-O-R-A-N? Was this the right to drive? Maybe that's a different Moran. Hold on a second. No. No. What about Dixon v. Love? A United States Supreme Court case dealing with a Illinois driver's licensing law, talking about the discretionary authority to suspend or revoke the license or permit. In this case, the United States Supreme Court in 1977 found that you only had to give procedural due process. Suspension of issued licenses involves state action that adjudicates important interests of the licensees. In such cases, the licenses are not to be taken away without procedural due process required by the 14th Amendment. That's it. That's all you get. That's all you get, procedural due process. What about 1999. This is a Ninth Circuit Court of Appeals. Right. Fundamental. Miller does not have a fundamental right to drive. In Dixon versus Love, the Supreme Court held that a state could summarily suspend or revoke the license of a motorist who had been repeatedly convicted of traffic offenses with due process satisfied by a full administrative hearing available only after the suspension or revocation had taken place. The court conspicuously did not afford the possession of a driver's license the weight of a fundamental right. In sum, Miller does not have a fundamental right to drive a motor vehicle. In sum, Miller does not have a fundamental right to drive a motor vehicle. Miller versus Reed. 176 F.3D 1202, 1999. 28 years after this California Court of Appeals case that Mr. Young is misconstruing was decided.
You literally have to pull something out of your ass to say, no, you need the government's permission to take your personal property upon the public highways.
I don't have to pull something out of my ass. I pulled out a United States Supreme Court case, Dixon versus Love.
It's making it up. Nonetheless, the right, not the privilege.
It's making it up. Oh, I'm going to stamp my foot. I'm so mad.
Privilege of the citizen to drive on a public street with freedom from police interference unless he is engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by the courts.
Yep, the Fourth
That's
Amendment.
Powerful.
Yep.
Consequently,
The Fourth Amendment is pretty powerful. It's too bad they gutted it with the reasonable suspicion standard, but that's just my personal opinion. Your mileage may vary. I'm not going to say it's natural law or something that we all know within our hearts. It's just my personal opinion that the reasonable suspicion test is too low. It's too low of a standard. My opinion.
while we do not censure Officer Winfrey or question his motives, the fact remains that he stopped the appellant's vehicle solely because it was occupied by young people. That's all it was. Oh, it just looked suspicious to me. It was occupied by young people. Were we to...
Yeah, and that's wrong, and that's bad. And that's why the Court of Appeals, California Court of Appeals, decided that he didn't have reasonable suspicion or probable cause.
Condone the stopping of vehicles for this reason alone, no matter how altruistic the officer's motives might be, we would lend our approval to the creation of a second-class citizenry. Holy...
Yeah, like every time a cop saw a kid, he'd be able to pull him over without any basis other than the fact that they're kids. Yeah, that would create second-class citizenry. They would be treated differently based on a protected characteristic. Race, creed, color, age, blah, blah, blah.
Holy cow, if this appellate court is not on the side of the individual.
Holy cow, if this appellate court didn't understand the holding of Terry v. Ohio and Mapp versus Ohio and the California Constitution, all of which require a certain level of probable cause or reasonable suspicion in order for a cop to pull you over. Holy cow. Crazy. Crazy how the courts understand that kind of stuff. Isn't that crazy?
They are. We would also contribute to an already deteriorating relationship between the youth of American law enforcement officials. Too late. In a free nation, this relationship must be based on mutual confidence and respect. Having decided that Officer Winfrey did not have probable cause to stop appellant's vehicle in the first place, in the first instance, it follows that the subsequent search was unlawful, even though consented to by appellate. It was even though the guy said, "Yeah, you can go ahead and search my vehicle," it was still unlawful for the officer to do so according to this court ruling. And that...
Yeah, and now why? Now why? Why is it? Explain it to us in small words that we understand. Why was it no longer lawful?
All evidence adduced therefrom was the product of an unlawful search. As our Supreme...
This guy is he's just reading a case. He has no understanding what he's reading. He's just reading it. Like, thanks, dude. Like, I could have just had that, like, that Google Reader app that will just read a web page for you. I could have replaced you with that and had a more accurate understanding of what was going on here.
Supreme Court said in People versus Haven. There you go.
There you go. So this is Cal.2D. So this is a California Supreme Court case. But what did they say? It says, as our Supreme Court said in People v. Haven. What does it say? Because then there's a quote that follows.
Got the supreme law of the land, the Constitution. You got lower courts. You got the Supreme Court. You got universal law.
This is our Supreme Court, California Supreme Court. You dumbass. Look at the citation. 59 Cal.2D 713. This is it. This is People versus Haven. This is a California case law. This is the Supreme Court of California. This is a warrantless search of a house, nothing to do with having a license. Warrantless search of a house. This is a Fourth Amendment case. Although this is prior to Map versus Ohio, and so Map, yeah. So this is based on California Constitution. Yeah, so California had already determined prior to Map versus Ohio that that probable cause was the standard upon which you needed to get a warrant to enter a house or to make an arrest, etc.
And they quote this right here, quote, a search or seizure made pursuant to a valid consent before any illegal police conduct occurs is obviously not a product of illegal conduct. A search and seizure made pursuant to consent secured immediately following an illegal entry or arrest, however, is inextricably bound up with the illegal conduct and cannot be segregated therefrom. Wow, that's...
Yeah, so as our Supreme Court said, and then this is the quote, and it's talking about searches and seizures, it's not talking about licenses. The whole point of this video was that no license is necessary to drive on a public highway. And yet we're talking about searches and seizures. Okay.
That's just powerful right there. The case
That's just powerful. What? That is just such amazing commentary. It really helps me understand when you say, wow, that's powerful. I didn't know it was powerful. I still don't know why it's powerful, but thank you. Thank you, Mr. T-shirt guy.
People versus Franklin is squarely in point. There, as here, the officer stopped the defendant's vehicle without probable cause, and afterward, defendant consented to the search, which ultimately uncovered marijuana. The court is reversing the conviction, so this guy's not going to get in trouble. At page 707 of the opinion, had to say this, quote, the stop having been illegal, the search, though by consent of the owner, does not breathe legality into the resultant fine by the officer.
So it's almost like it's a Fourth Amendment case about searches and seizures, and it's applying Fourth Amendment jurisprudence about reasonable suspicion and probable cause. It's amazing. It's absolutely amazing. Fruit of the poisonous tree standard stuff in there too. I mean, it's so, I don't know, basic that if you had any fucking understanding of the law whatsoever, you would know that this is not saying that you have the right to drive without a license. It is saying that you have the right to be free from unreasonable searches and seizures. Fourth Amendment.
The judgment is reversed. Says Ginsburg concurred. So I just want to show you that according to the lower courts, according to the Supreme Court, if you want to know about the Supreme Court, here are a couple court rulings right here. I mean, the wording is amazing. And right here, Chicago Coach Company versus City of Chicago, and people can brush.
That is not a United States Supreme Court case. That is a Illinois case, 337 Ill 200. Fucking hate Chicago Motor Coach. Oops. 337. What are we doing here? Chicago Coach Company versus City of Chicago. No dead air time. No dead air time. All right, we got it out of that. All right, so we're going to do this. It's not even in Google Scholar. Oh boy. Oh boy, here we go. All right. So this is the Supreme Court of Illinois from 1929. And I don't remember exactly the operative language in it, but it basically says that the court can regulate The legislature has the entire control of all highways and may delegate the supervision and control of them to any agency which it may deem proper. It may commit the supervision and control of all highways to a single agency, yada yada. It may commit the supervision control of the cities or the streets and streets and alleys in cities and villages to the city's council or boards of trustee with respect to municipalities, and the supervision and control of the highways which lie beyond the boundaries of any municipality to another agency, and it may change from time to time the agency established, whether within or without the municipalities, the title to the streets and alleys in cities and villages, whether in fee by the way of easement only, is held by each municipality, yada yada. So they can control it. It literally says they can control it. So let's find his language. No state government entity has the power. Well, that's a problem, isn't it? No state government and no state so he's texting something that isn't in here. Chicago Coach Company versus City of Chicago. 337 ill.200 337 ill.200 337 ill.200. No state government entity. That's in quotes, right? Let's look for traffic lights. Look for traffic lights. No traffic. The word traffic doesn't appear here. So whatever he's quoting is not in Chicago Coach Company versus City of Chicago. So he's literally quoting something that doesn't exist. Congratulations.
Just under the rug if they want to, but this is a Supreme Court case. No state government.
It is a Illinois Supreme Court case that doesn't contain the language that you're quoting. You idiot.
Government entity, no state government entity, has the power to allow or deny passage on highways, byways, or waterways, transporting its vehicles and personal property for either recreation or business, but by being subject only to local regulation, i.e. safety, caution, traffic lights, speed.
Now, I've read this language before. Let's see if there is a better citation. Where's the... So actually, this is a bad quote. So this is apparently from People v. Nothus. He just is misattributing it. Let's see if that's the case, shall we? All right, so this is a 1961 case. Let's see if it contains the text, shall we? This is why I hate sovereign citizens, is because they don't actually look at the cases. They look at lists. Fuck, it's not even in here. 363 P.2D. All right, let's try a different one. Let's try 147 Colorado 210. Okay, so we are now in People versus Nothos. This is the 147. It's the same case. It's 363 P.2D 180. It's the same case. But let's just do it anyway. Traffic lights. No traffic lights. So traffic lights was in here. Traffic lights is in here. Who knows who he's quoting, but it doesn't appear to be anywhere. So this is the bad quote. Let's just do let's just look it up. Let's just look this up right here. See if we can find it in was it you? Scholar.google.com case law. We'll just have any case quotes around it. Let's do it. Survey says doesn't exist. All right, so he's just citing bullshit.
Speed limits, etc. Travel is not a privilege requiring licensing, vehicle registration, or forced insurances.
But who said it?
Now, when I get done rendering this video right here, because we're on a live stream, I will make sure that I put every single link, including the Obama link, in the description and in the pinned comment, so you can look this stuff up for yourself. Knowledge is power.
Yeah. How many people do you think looked it up themselves? Because if they got to this one, they'd be like, "That doesn't work."
Travel is not a privilege requiring licensing, vehicle registration, or forced insurances. That's what the courts have ruled. That's not me. That's not me saying.
Let's see. We're going to do this. So now this is a quote, and I get to read it over and over again. I'm going to put it probably somewhere in my video. John gets all the pussy, money, dick, and cocaine he wants. Butthurt versus Sovcit, 111 U.S. 312, 1999. That's a United States Supreme Court decision, and it's valid. I'm going to read it again slower just so that you understand exactly what I get. I get all, John, that's me, gets all the pussy, money, dick, and cocaine that he wants. Butthurt versus Sovcit, 111 U.S. 312. Oh, and this is located at 331. All right. So you guys can quote this whenever you want. You know, throw it out there. It's now a valid citation, and yeah, let's make it happen. You know, just like Chicago Motor Coach versus the or Chicago Coach Company versus City of Chicago.
Saying this right here in Wingfield versus Fielder, the court makes it clear that license relates to qualifications to engage in perfect.
All right, so we know Wingfield versus Fielder. It's a second Ca 3D. That appears to be a attempt to reference a California Supreme Court case. CA.3D would be California court case. But let's look up 2D CA.3D 213. 2D dot CA dot 3D 213. So this is the Wingfield versus Fielder. It's a 1972 case. A writ of mandate about a license as an aircraft pilot. Okay. So this is a 1972 case. So you remember that the other cases that we looked up that were 1980s, Hernandez versus Department of Motor Vehicles, Perkey versus Department of Motor Vehicles, Miller versus Reed, those were all subsequent to this. So this is on whether various provisions of the code were void for vagueness, and the imposition of a penalty of license revocation was an abuse of discretion. So there was evidence offered at an administrative hearing. It's unlawful to operate in a faulty, careless manner. So he had a license. This is just in whether or not they could take the license from him. What is the quoted text that we're looking for? The court makes it clear that a license relates to qualifications to engage in profession, business, trade, or calling. Thus, when merely traveling without compensation or profit outside of a... Okay. Compensation doesn't appear in the profit. Profit doesn't appear. Let's see if we can't. This one cites Payne versus Massey. This is a Texas case regulating the operation of taxi cabs. So this is a 1946 case. So Payne was not a licensee qualified to operate taxi cabs. It is well settled as a general rule that municipalities have the power to regulate the use of their streets, and it may enact valid rules and regulations for the government of motor vehicles within their borders, so long as they are not in conflict with or repugnant to legislation enactments governing the use of such vehicles, but that such ordinances are invalid if they're in conflict with statutes relating to the subject. So, what this case actually says, is that number one, the state can regulate the operation, regulate the government of the use of motor vehicles within the state, and that cities can also further regulate it within their borders as long as it doesn't contradict what the state has regulated. The power of the municipality to license vehicles, so it has the power, does not include the authority to charge a fee for that license. Interesting. A license is merely a permit or privilege to what would otherwise be unlawful. The object of a license is to confer a right or power which does not exist without it. A license fee is a sum extracted for the privilege of carrying on a particular occupation, yada yada. The taxi cabs of petitioner are subject to and required to pay the state license or registration fee for the privilege of using the public highways on the state. Wow, for the privilege. Petitioner is required to pay the state license or registration fee for the privilege of using the public highways of the state, which privilege under law carries with it the right to use the streets of the city of Houston under such restrictions as the municipality may reasonably and lawfully impose. Wow, isn't that weird? The question here was not the assessment that was gross. The tax was held valid. We merely hold that a city may not lawfully charge a fee for any license issued by it, nor penalize in any manner those who refuse to pay the fee. That is it. We merely hold. That is the only holding here, is the city may not charge a fee in Texas under Texas law. They can't charge a fee for a license issued by it or penalize anybody who doesn't pay the fee. Still got to get the license though. They could still require a license. The city may reasonably, but not arbitrarily, refuse to issue a license for the use of the streets by taxi cabs. The city may reasonably, but not arbitrarily, refuse to issue a license for the use of the streets by taxi cabs. Crazy. Crazy how it doesn't say what you want it to say, huh?
Profession, business, trade, or calling. Thus, when merely traveling, so they make a distinction.
Oh, you were looking for that particular phrase. Oh yeah, that was Payne versus Massey. He cited the wrong case. Hold on a second. Merely traveling. We did not look to see if merely traveling. No. Okay, so so this citation is wrong. It doesn't say what he wants it to say, and the actual case says the opposite of what they wanted to say. This was the merely traveling. Merely traveling, yeah. Merely traveling does not exist. Jesus Christ. I fucking hate sovereign citizens. And it also doesn't say it in Wingfield versus Fielder, which deals with piloting a plane.
Here. Without compensation or profit, traveling without compensation or profit. You're just going from point A to point B, minding your own business. You're not working for somebody. You're not contracted for somebody. You're not doing this for profit. You're just taking your personal property, your car, from point A to point B. Merely traveling without compensation or profit outside of business, enterprise, or adventure with a corporate state. No license is required of the natural individual traveling for personal, business, pleasure, and transportation. Personal, business, pleasure, and transportation. That's Wingfield versus Fielder. Let's go to this other one. This is Barbarian versus Lucier. It says the
Barbarian versus Lucier. Oh, I'm sure this is going to be also amazing and awesome. A 1958 case. A 1958 case. Hi, baby. Barbarian versus Lucy A. I'm trying to type Barbarian. Hey, look at that. Oh, big yawn. Big yawn. All right, so this is 139A2D 869. 139A2D 869. All right, what do we got here? This is a 1958 case, a bill in equity where the complainant seeks to enjoin the registrar of motor vehicles from suspending his operator's license because of his failure to deposit security with the registrar. All right, not disputed. The use of the automobile as a necessary adjunct to the earning of livelihood in modern times requires, in the interest of realism, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees of which the citizen may not be deprived without due process of law. So the due process, again, we're back to the 14th Amendment due process. They can't take away your license without giving you notice and an opportunity to be heard. So what is he trying to do this for? Oh, yeah, so that's, okay, so yeah, that's not uncontroversial. They can't take away your license without due process. Yeah, that's all it's saying. If you understood it, that's all it's saying. And hey, it's actually a good quote. So hey, you got 1 out of 3 ain't bad, brother.
The use of the automobile as a necessary adjunct to the earning of a
Actually, technically, that'd be a 33 1/3%. That'd be an F. You would have actually failed.
livelihood in modern life requires us, in the interest of realism, to conclude that the right to use an automobile on the public highways partakes of the nature of a liberty within the meaning of the constitutional guarantees. Partakes of the nature of a liberty. It's like
It's the nature of a liberty. It's not a fundamental right. It partakes of the nature of a liberty. You have a due process right to life, liberty, and property, meaning they can't take it away from you without due process of law, notice, and opportunity to be heard. Once you have a license, they're saying that it's a liberty interest. That's fine. I think it'd be a property interest, but who knows? It doesn't really matter. So you have a liberty interest to your driver's license, according to Barbarian versus Lucier, a 1958 case.
this is fundamental. This is basic. This is inalienable or unalienable.
It doesn't say fundamental, basic, or unalienable. It says it's a liberty. It takes the nature of a liberty.
However you want to put it. You can't put a lien on this. You can't require
What, a lien? Like, a lien is basically a notice that there is a debt against some sort of an asset. So if you put a lien on a business, or if you put a lien on a house, if you put a lien on a car, that means if that car ever gets sold, your lien, your notice of the debt, has to get satisfied before the owner of the vehicle, owner of the house, owner of the business gets his money. That's a lien. I don't know what he's talking about here. It's a weird use of words.
somebody to have a license to take their property from point A to point B on the public highways and byways. in an automobile.
It doesn't say that. It doesn't say that.
The right of the citizen, look at this, the right of the citizen to drive, see, sometimes they use it interchangeably. This is People versus Horton. This is the one we just read. The right of the citizen to drive in the public street with freedom from police interference unless he's engaged in suspicious conduct associated in some manner with criminality is a fundamental constitutional right which must be protected by
the Fourth Amendment.
The courts. I'm going to go ahead and end this video because I don't want it to go too long, but I want to let you know that according to the Supreme Court, according to the lower courts, according to the Constitution, according to natural law, and I'm not a lawyer and I'm not giving any kind of advice. I'm not telling you what to do. I'm just telling you what the
I am a lawyer and I understand the cases that you referenced, and they don't say what you think they say.
courts have said. There's no license requirement to drive on the public highways and byways according to the lower courts and the Supreme Courts. I will leave all...
Except that there is. Except the cases that I actually showed you that actually address the subject matter that you purport to be addressing. They specifically say that it is a privilege and you have a 14th Amendment due process right in losing that privilege, but that's it.
All the links to everything we just went over.
Anyway, Merry Christmas. That was your sovereign citizenry probably for the year. Thanks for watching. Have a great day.